Okay, so tonight we're going to be covering the topic on establishing contractual terms. In particular, we're talking about implied terms. So as we will later see, there are actually two aspects to implied terms, mainly because on the one hand, courts are prepared to imply terms for the purpose of ensuring that the bargain between the parties become completed, assuming that there is a term that seems to be absent. And secondly, in order to save a contract. So there are certain terms that are crucial, like it could be a price, and it could be a question as well of, let's say, delivery. And so if those terms may be considered to be so crucial to the contract that in their absence, it might be said that a contest ad idem couldn't have happened. In other words, the parties couldn't have agreed to enter into a contract in the absence of those implied terms. That's one aspect. The other aspect is it's really for the purpose of determining, assuming that a contract is in fact valid because the contract is complete in most terms, but there is a term that seems to be absent, which term isn't really that important to the validity of the contract. In that case, rules on implied terms will also kick in. So we've already covered that aspect where courts would intervene for the purpose of confirming the validity of a contract in the absence of key provisions, without which a contract would fail, mainly because of the absence of a key term, which might be a condition. And so the example I gave would be price, assuming that it wasn't there. It could be a question of quality that wasn't discussed, but the court would step in because the absence of a presumed understanding between the parties as to what the quality of an item might be, then the contract wouldn't have been entered into in the first place. But the second aspect of the notion of concerning implied terms would be when courts intervene, mainly because there is another term that is missing in the contract. The contract wouldn't fail in its absence. The contract would still be valid, but the courts would try to intervene for the purpose, for instance, of ensuring that the intentions of the parties are promoted. So tonight, we're going to be focusing on the notion of implied terms. Now, before I continue, would there be any questions that either you, Luke, or Heidi might have? How exactly do I pronounce your name, Luke? Is it Luke or Luke?
Yeah, it's actually Luke.
Ah, okay. Yeah. It's actually Luke. Because sometimes, in fact, when I look at the dictionary sometimes, the best way to pronounce it seems to be Luke with a Y. So it's actually Luke in your case.
Yes, it is. I mean, I will pretty much answer to most things anyway. I'm pretty used to different sort of interpretations of it, so it's all good.
Okay, good. Okay. Would there be anything that you'd like to raise first as a question or comment before we proceed with tonight's tutorial?
No, I'm all good on this front. I've done a little bit of the reading today just to kind of refresh my mind of it, so I think I'm pretty good.
Very good. Okay, so we could probably begin then. So after completing the tutorial, you should be able to discuss and explain the following concepts: the distinction. Hold on, wait. So I got that. Okay. So after completing this tutorial, you should be able to discuss and explain the distinction between implied terms, which give effect to the intentions of the parties, and those which are implied as a matter of law, and the key considerations the law will exercise when implying terms into contracts to give effect to the intentions of the parties, along with the rules which apply to each. So let's begin by looking at a scenario for the purpose of better understanding the principles on implied terms in contract law. And I'm going to have to ask one of you to read the tutorial question for us. Would that be Luke or Heidi? Okay, thank you.
Lachlan was a computer geek who, there you go. He was developing and flourishing home-based business trading virtual items in the game World of Warcraft. In fact, his business was going so well he needed another computer. His requirements were quite specific, so he contacted his friend Trissa, who was more of a nerd than a geek, but very good with computers. She agreed to build Lachlan a custom computer to meet his specifications. He gave her a range of specifications regarding proceeding speed, graphics drivers, memory capacity, screen size, and Wi-Fi capability. She said it would be no problem and quoted him a price he was happy with. A week later, she left the computer in a box on Lachlan's landing. When he got home, he unpacked it in a state of sublime excitement, but then found that the computer had no keyboard. He called her to let her know she had forgotten to include the keyboard. She said, "No, you did not order a keyboard. That was never the part of the quote. You need to buy one." Lachlan was very upset. He told her she was being ridiculous, that a computer was useless without a keyboard. She answered, "I know, you should have thought about that when you sent me the specifications. Now go away and buy a keyboard. I'm busy playing Call of Duty." She hung up the phone.
Go on. There's another part there.
Sorry. So, left with few options, Lachlan went to a retailer and bought a new keyboard. When he got home, he was chatting online with his friend Sunil, and he told Sunil about a new World of Warcraft business opportunity he had identified. Sunil did not say much about it. The following day, Sunil contacted Luke to offer him $100 to complete a chapter in a new book he was collaborating on for a new online role play gamers. The only problem was the chapter needed to be written within 3 days. Lachlan jumped at the opportunity and started writing. Meanwhile, Sunil went straight online and snapped up the business opportunity Lachlan had been discussing. While Lachlan was diverted writing the new chapter, Sunil then contacted Lachlan to tell him that he didn't need the chapter after all, so there was no need for him to complete it. Lachlan had only spent a few hours on the chapter, so he agreed in writing by email just to terminate the contract without asking for any money. After Lachlan found out Sunil had moved in on the business opportunity, he felt betrayed and sought your advice. Without laughing at the idea of a grown man making money on World of Warcraft, advised Lachlan on A, whether he was entitled to a keyboard from Trisha, whether his agreement with Sunil included any relevant implied terms, whether he should be paid $100 for writing part of the chapters despite his agreement not to ask for any money.
Okay, thank you, Heidi. So can I just get the two of you to, when you could, post your answers in the chat box, and then we can proceed from there. It was all right, Heidi. So let's begin with the first question. Whether he was entitled to a keyboard from Trisha. So the first question is, let's just begin with the first question. Don't answer the three questions first. So the first question is whether Lachlan was entitled to a keyboard from Trisha. So the answer would be yes or no. And whatever your answer is, if you could also provide a reason why it's a yes or no. Uh-huh. Yes, Luke.
Sorry, I was going to say, in regards to question A,
Yes.
I don't think he was entitled to the keyboard because he was very specific on all the things that he needed.
So that would be the reason. So your answer would be he wouldn't be entitled because he was quite specific in what he wanted. To what he wanted.
Yeah, because he goes into detail saying about processing speed and graphics drivers and all the specifications that he wanted, and it doesn't actually. Has never confirmed what actual components he needed. Like if he needed a monitor, or if he needed a keyboard, or if he needed a hard drive, or any external properties. It was actually just for the basis of a custom computer.
Okay. Sounds like a good answer. How would you respond to this question first of Heidi? She's asking a question whether the computer was a desktop. So remember, we're trying to answer the scenario based on whatever the facts are. So we're not adding anything else. So we basically make assumptions. So we make a decision, or we arrive at a conclusion based on the scenario that's given.
I believe he should be entitled to it because the computer should come with a laptop. I mean, with a keyboard. But I am now thinking about it again. If I were to buy a computer, I would expect to get a keyboard. But like Luke says, the specifications kind of come in on that and kind of trumps it, I guess.
So what's your answer there? Your answer, Heidi, would be that.
I believe I believe he should be entitled to the keyboard.
Okay. Why would that be the case?
Just from a buying a computer standpoint, like I haven't obviously I should be thinking about a contract standpoint, but I believe the computer should come with a keyboard, just on the fact that if I buy a desktop, I would expect have a keyboard.
Okay. So we've got two conflicting answers. Luke, would you like to respond to what Heidi said?
Yeah, sure. Well, basically, I'd look at how computers are sold. I'd have to have a look at, go to a big retailer and have a look at how they're generally packaged, because I know sometimes they don't always come with a keyboard. It actually does depend on what you're looking for. Now, when it comes to Lachlan, he's actually just specifying that he wants his computer to meet these certain requirements. He's not saying it's got to have a CD-ROM, it's got to have a web camera and stuff like that. It's actually just components that someone with the knowledge of Trisha would assume is just the actual computer section, not the monitor or anything like that. And Lachlan, being someone who's pretty savvy with computers himself, would probably have a reasonable idea of what he wanted. So if he wanted a keyboard, he would know to say yes, and it needs to have this type of keyboard. He would generally sort of specify what he wanted.
Okay.
And so, yeah, that's how I'd respond.
How exactly would one understand the idea of a computer? Is a computer a CPU, or is a computer a product which you can actually use for a specific purpose, such as in the case of Lachlan, he needed it for the purpose of running his home-based business. Can you have, so it was quite clear based on the facts that he wanted a computer. He needed another computer, because for his flourishing home-based business trading virtual items in the game World of Warcraft. Can you actually conceive of a situation, or can you actually argue that you can have a computer that would meet the needs of Lachlan in the absence of a keyboard?
From a consumer perspective, I would say that you can, because I'm pretty sure you're able to actually join up two separate sections of hard drives and actually incorporate them into one system. But from a contractual perspective, I'd look at his necessity for it. Did he necessarily need it to conduct his business that he had running?
Okay. Now, let's begin by asking the fundamental question here. What exactly is the approach of courts when it comes to implied terms? Is it would courts approach a problem such as this by implying a term? Is that the presumption? Is that the basic approach of courts? Would courts imply a term as a matter of principle? So how does the court proceed? Does it proceed under the assumption that it should imply a term? And if so, why would a court seek to imply a term? What is the general rule? Heidi, Luke?
So from what I can gather from the textbook is basically a term will be implied to reflect the intentions of the parties in the contract.
Okay. So is there an assumption that the courts, as a matter of principle, will actually approach a problem by being prepared to imply a term that hasn't been discussed or that may have been omitted by the parties? Is that the presumption that we have? So when we're dealt with a problem scenario such as the one we have now, do we approach the problem by assuming that a term should be implied in order to complete a contract, or in order to have a term that may have been omitted become part of a contract? Is that the initial approach by which we look at problem scenarios such as the one that we have?
I'd say the court that would actually read the contract and try and narrow down if a term is implied by taking into account all the facts and everything. So yes, I'd say the court would imply a term.
Okay, so let me just clarify that. Are you suggesting that as a matter of principle, courts will approach problems where there is a term that seems to be missing? The initial approach of courts will be to imply a term. Is that the way that courts would approach a problem where there is a missing term?
Sorry, it would depend on if the language used and the terms already in the contract, if any of them were ambiguous or not, or if there was any uncertainty in separate sections.
Okay. So let's begin with the presumption, or with the proper approach here. If there is a term that is incomplete, or a term, contract seems to be incomplete because a term is missing, the initial approach of courts is not really to imply a term. So that's the initial approach. Courts will not seek to imply a term. Why would that be the case? Why shouldn't courts seek to imply a term that is not in a contract? What do you think? Okay. So as pointed out by Heidi, because the parties need to agree upon it. So remember, as a basic proposition in contract law, there is a freedom of contract. There is a principle of autonomy of the parties. The courts, as a matter of law, the law will give the parties freedom to contract. So the courts will, as a matter of law, the courts and the law will not intervene with the way that parties enter into a contract. So the parties, for example, decide that you have a lopsided agreement, so the one is clearly at a disadvantage, or it may be that there should be a term that, if not read into it, will actually put a party at a disadvantage. As a matter of principle, it is not going to be the task of the courts to save a party from his error or his omission, because the main principle is that the courts leave it to the parties to enter into a contract. There's such a thing as a freedom of contract, which also means that given that there is a principle of freedom of contract and the autonomy of the parties, it also means that the parties, therefore, can freely decide to enter into a contract that is hugely disadvantageous to another. So there is nothing illegal, there is nothing inherently wrong with a situation where, when a contract is entered into, one of the parties is put at a disadvantage. If the parties agree that that is the case, so let's say I sell a computer to you, and the usual price for a computer is $1,000, and I agree to sell it to you for $50. So putting it at a disadvantage, is it going to be the job of the court to nullify the contract because somebody is at a disadvantage in entering into the bargain? Would that make sense? I mean, would it be fair for the courts to intervene? So as a matter of law, courts leave it to the parties to enter into a contract and to determine whatever the stipulations should be, whatever the terms of the contract should be. There is a statement here from ID: the court will only agree, disagree if there is a contract. What does this mean, Heidi? The courts will agree or disagree if there is a contract.
I was only asking if the court would only agree or say that there's a contract, not imply the terms of that contract. If that makes sense, like the court would only will the court only decide whether a contract was formed, or will, like you were saying, that they will not imply terms, but they will notify the parties that there was a contract made?
Okay, so it's probably just the way that the statement was worded.
Yeah, sorry.
Okay, so courts have no role in agreeing or disagreeing with the contract. The court may disagree with the contract. They're not involved in as far as contractual relations are concerned. It's not the role of the courts. So the courts would only intervene if there is a dispute between the parties, and the intervention of the courts has nothing to do whether or not they agree or disagree with the contract, in the sense that somebody may be at a disadvantage. So
okay.
Now, however, if the other point you were raising, Heidi, was, what was that again?
Oh, I was just saying if whether they were gonna enforce that contract because they decided there was a contract made. I just didn't understand that they wouldn't agree or disagree that there's a contract made. I understand that.
I see. So okay, you're right. So you were actually saying that the courts will have to make a conclusion, arrive at a finding of whether or not there was a contract in the first place. Was that what you were saying?
Yeah, I understand it now.
That's right. That's true. So what it actually means is that typically when you have a dispute between the parties, and especially where there seems to be a term that is critical to the formation of a contract, and that term is missing, which could be the price, or it could be the quality of the product that they agreed upon. Like in this case, what exactly is a computer? Does it include a keyboard? Does it include a monitor? So because of that dispute, the courts will need to determine in the first place whether a contract had been formed, right? Because the rule is, if there is a crucial term of the contract that is missing, such as a price. So you therefore have an incomplete contract, or a contract that then becomes uncertain. Then in that case, there might not be a contract in the first place, because in that case, it is difficult for the courts to intervene and supply the uncertainty. So courts will only save an uncertain contract if it could. If in the first place, it can be assumed that the parties would have reasonably put their minds, if the parties had given an opportunity to reasonably put their minds into arriving at an agreement on that specific term, and they would have agreed, therefore, that this would be the term that should be supplied. But as a general rule, if a contract is incomplete because a crucial term is missing, such as a price, then the courts will say that the contract is void and unenforceable. That will be the general rule. So in that case, you are correct. Courts will proceed first by determining, was there a contract in the first place? Now, secondly, assuming that the courts will agree that there is in fact a contract. So let's begin with that question. Was there a contract between Lachlan and Tricia? So in the absence, so it's clear that the parties failed to agree whether or not there was a term. I mean, whether or not there was a keyboard. So that's clear. The question is, was there a contract, was there a valid contract still between the parties? Let's begin with that, because that's probably okay. So we can agree that there was a contract. Why do we say that there was a contract in the first place?
I was saying there was a contract because Trisha's actually gone and quoted a price, and he was happy with it and has accepted. It's implied from this reading that he has accepted those terms and has provided consideration.
Yes. So if you examine the scenario, it's quite clear from the context that there was clearly a contract between the parties, and the parties intended to be bound. But there is, however, so from Heidi, because all the terms were agreed upon, no terms are left unagreed to pursue. And so in other words, the failure of the parties to agree on whether or not the keyboard should be part of the contract does not really detract from the fact that there was a consensus ad idem as to what a computer is, mainly because they agreed on the specifications. So there is no question that there was a contract that was formed. And so therefore the disagreement relates to a missing term, which is in relation to a keyboard. And so therefore the approach of this court, remember, is that the courts will not imply a term. The courts will not approach a problem of this sort for the purpose of implying a term, mainly because the courts begin with the presumption that as a matter of law, parties should be permitted to enter into bargains by themselves. And if they omit an important point, let the chips fall where they lie, whoever may be at a disadvantage, that is the problem of that person, mainly because of the autonomy principle of contract law. Now, as we know, courts will only intervene if it can be assumed that the parties actually intended for an implied term to have been there, but somehow they forgot to include that term. So the only time, well, there's the other aspect of, obviously, when, as a matter of law, courts will imply a term. But in general, courts will only imply a term if it can view a transaction as such that the parties would actually have intended for a term to have been part of the contract. So you have a situation here where that is difficult to conclude, because on the one hand, you obviously have you obviously have a set of specifications that was agreed upon by the parties, and that did not include a keyboard. Now, so we agree, therefore, that based on the facts, Lachlan would not have been entitled to a keyboard, as argued by Luke. It is mainly because, given the fact that Lachlan actually provided a set of specifications as to what the computer should be, the absence of a keyboard in that set of specifications would lend to the conclusion that that was never part of the bargain in the first place. So we make that assumption. So there was a contract, it was quite clear, And the absence of the failure to state whether or not a keyboard should be there does not go into the heart of the contract. It does not invalidate the contract. So there is a contract. And given the fact that there was a set of specifications that lends itself to the conclusion that that was omitted on purpose, even if it had not been omitted on purpose, you will have to arrive at the conclusion that that was never part of the bargain, at least in relation to one of the parties. So you cannot have a situation where you can say that both parties would have intended a keyboard to be part of the contract. Now, the other question I asked then is, we're not moving to questions 2 and 3 yet. The other question that I would ask then is, assuming that the parties did not come up with a set of specifications as to what the contract should comprise of, okay? So if you follow the scenario, therefore, Lachlan would have come to Trisha, who is his friend, and asked that a computer that would meet his needs in relation to his flourishing home-based business needed to be set up, or how do you call that? Set up or assembled by Trisha. And Trisha agreed. If that was the scenario, so let me repeat, Lachlan came to Trisha saying that he needed another computer for his flourishing home-based business. And Trisha said, yes, I'll make you one. And they agree on the price. They did not agree on the specifications. The question is, if that were the case, and in the process, Trisha did not supply the keyboard, would you say, as a matter of law, or the way that the courts would approach the problem, would you say that Lachlan would have been entitled to a keyboard from Trisha?
I'd say then that he would be entitled.
Why is that?
Well, I'm going off how the court will make reference to custom and usage. They'll look at, because they're both very computer savvy, and it's probably understood that when someone says a computer, without going into finer details, they generally will mean a whole computer of different components.
Okay, because you raised the notion, Luke, concerning usage, and you're correct. You're citing the fact that both under the scenario are actually quite familiar with computers, because Lachlan in the scenario is a computer geek, and Trisha, obviously, who is more of a nerd than a geek. So obviously, but Trisha is also quite familiar with computers. So it's possible to argue the notion, for example, of usage. But we're going to go back to that in a short while. But the question I ask is, assuming that one of them is not actually a computer geek, would your answer be the same?
Yes, it would be still.
Okay.
Because then it relies on the person who has the most knowledge in regards to the situation. Say, for example, a salesman, mechanic quoting prices to fix a car of someone who has no idea about cars.
Okay. But what exactly is the general rule concerning usage? There are certain principles that have to be met. How would, for example, a court even arrive at the idea that it is part of usage or custom that a keyboard is part of a computer? When we say usage or custom, what exactly does it mean?
Sorry?
How do we know that something is actually part of usage? Meaning a term should be implied as being part of usage. How do we mean by that? How do we arrive at that conclusion?
I was more going off the custom side of things, because it's more relevant to everyone within a certain industry knows about a certain custom,
Yes.
and it goes without saying that it's obvious that everyone within that industry knows about it.
Okay, so when it comes, therefore, to the idea of implying a term based on general customer usage, when we say this, it's usually in the context of such a customer usage being part of the regular dealings of an industry or a commercial sector to which the parties belong to. So in other words, there is a narrow area where a court would actually imply a term based on general customer usage. A court will not therefore necessarily imply a term to be part of a general customer usage. So in general, this would be in the context of a usage or custom from the viewpoint of an industry or commercial sector to which the parties belong to. So therefore, in the change scenario that I gave, we had made in the first place the assumption that Lachlan wasn't a computer geek. So in that case, we make an assumption, for example, that usage may be inapplicable. Okay, so in other words, the courts again will not presume that the term should be implied from general custom or usage. That is something that has to be argued by the parties or by the party seeking for a term to be implied. But courts will not step in to assume that a term should be implied based on custom or usage. And in that narrow area where a court will imply a term as being part of general custom or usage, it is usually in the context of dealings between parties who are part of the same industry or commercial sector. Because otherwise, if they don't belong to the same industry or commercial sector, how can you assume that the parties actually intended for a term to be part of their agreement? So the court will only assume that the parties would intend a term to be implied as a result of a general customer usage if the parties actually had an opportunity to know that a term should be implied as part of a general customer usage. So that cannot happen in a situation where both parties do not belong to the same industry. Okay, now the second aspect is when we speak of general customer usage, the understanding again is that customer usage should be well known. And that in general, the parties agree, or the people in an industry would assume that when they enter into a contract, whatever is that customer usage, they agree that should actually be part of a contract, and that it is implied. But the assumption really is that they have a sufficient opportunity to know that is really part of an industry. Even if in the end, they may not have prior knowledge of it, but as a general rule, people who belong to that same industry or business or sector would have a general idea that a term should be implied as part of general customer usage. So here, if we change the scenario, therefore, we can say that usage does not come in. But again, to move on, there is, however, another principle of common law that I thought I was losing the electricity there for a while. It flickered. So there is a common law rule that when it comes to contracts for the provision of goods and services, there is an understanding that whatever goods or services are being provided by one of the parties, they must be fit for the purpose. Was my light flickering?
I believe so.
Yeah, okay. First time happened. Okay, so let me just say that there is a common law principle that when parties enter into a contract for the provision of goods and services, there is an implied term that the goods that are being provided must be reasonably fit for the purpose. Okay? So having said that, therefore, it can actually be argued that there should be an implied term that when the parties entered into a contract, Lachlan and Tricia entered into a contract, whereby Lachlan wanted I'm just going to turn off Heidi. Heidi, can you just turn off your mic for a while? Thank you. So assuming in that new scenario where there was no specification as to what the computer should be, if what Lachlan then suggested or asked was for Trisha to assemble a computer for Lachlan, which he would then use for his computer business, it would then be arguable, according to common law principles, that the idea of a computer should actually involve a keyboard, and that it should also involve a monitor, even if it had not been agreed upon, because otherwise it will be ridiculous for the parties to agree that, when you speak of a computer, it's actually just the CPU. Because what exactly is the CPU? Is just it could just be the board, right? So the courts therefore will assume that when the parties agreed to have a computer assembled for Lachlan, it would have been, the courts will assume that it was the intention of the parties that was a full computer which would be fit for the purpose. So an argument, therefore, in that case, in the new scenario where there was no specifications involved, an argument could be made, citing common law principles, that the provision of goods and services should mean that those goods and services must be fit for a purpose. On the basis of those common law principles, it can be argued that when Lachlan asked for a computer to be assembled by Trisha, the notion of a computer actually should involve a keyboard as well as a monitor, because you cannot have a keyboard, you cannot have a computer without a monitor and a keyboard. In the same manner that when you purchase a car, somebody cannot deliver a car and then say, a seat is missing, or a door is missing, or a windshield is missing, or a side mirror is missing, right? So when you purchase a car, we have an idea as to what a car is. If it has to be fit for a purpose, those are basic things that have to be there. And you don't have to, in other words, it would be unreasonable for the parties to have to detail in a contract what a car should have. That it should have a wiper, that it should have this and that. Correct? So there is a common law principle that when there is a provision, so not even in a commercial context, purely from the viewpoint of contract law, then when parties enter into a contract for the provision of goods and services, those goods and services must be fit for purpose. Now, in the scenario that we have, the only reason why, in the scenario that we have, Lachlan is not entitled to a keyboard is because they had agreed to a set of specifications as to what the computer should be, and they had not agreed that a keyboard should be part of it. And for that reason, it would be difficult for the courts to presume that a term should be implied that a keyboard is part of the bargain, because of the autonomy principle that parties should be free to bargain with themselves as to what a contract should contain in terms of terms. Okay? Now, so let's move on to question 2. Now, whether or not the agreement with Sanil includes any relevant term. So in this case, when you say it's in any relevant term, based on the facts that was given in the scenario, what relevant term do you suppose are we referring to here? So going back to the scenario, what relevant term is being suggested here? What were the relevant terms? There were 2 potential sources of bargain based on the facts, right? In relation to Sanil and Lachlan. What were they? Well, okay, because we're running out of time, let me just say it. One is in relation to Sanil asking Lachlan to write a chapter for him. But the other aspect was Lachlan telling Sanil about an online business opportunity. So those are the 2. Okay, so let's begin with that first one, because we're just kind of rushing things here. Would you suppose, or can you argue that part of the agreement between Sanil and Lachlan was an implied term, that when Lachlan informed Sanil about the online opportunity, Sanil was not going to seize on that business opportunity for himself? Could that term be implied?
Yeah, I'd say that it could be implied.
Okay. Heidi, what do you think?
What was the question again? Sorry.
So the question is, based on the facts, Lachlan had informed Sanil that there was an online business opportunity. And at some point, Sanil, on his own, decided to exploit that business opportunity and did not include Lachlan in the process. So the question is, do you suppose that a court can imply that there was an implied term in the bargain between Sanil and Lachlan that Sanil was not going to profit from that business opportunity on his own without involving Lachlan? Could that term be implied? That Sanil cannot exploit the business opportunity on his own or for himself. Could that term be implied? So from Heidi, I believe so. Why would you argue that the court will imply that term should be? Why would you argue that a court is likely to imply that that term should be part of the agreement? On what basis is that? Again, we go back to the general rule. Will courts imply such a term? Could it have been the intention of the parties that Sanil could not profit from the business opportunity on his own? If you look at the facts, does the factual scenario appear that way? The answer should be a clear no. It should be a clear no. In the first place, there is, I'm sorry, yes, Luke.
Sorry, I was going to say, yeah, I just reread it again, and it doesn't seem like there was even a contract between Sanil and Lachlan in regards to the online business opportunity. There was no confidentiality stated for Lachlan's information. He was just talking to his online friend about a situation, right. And Sanil has actually decided to go for it himself rather than including Lachlan. Like, the only contract I can see is between Sanil and Lachlan when he offers him $100 to write a chapter in a new book.
That's right. So that's correct, Luke. So again, as a matter of approach, courts will not approach a factual scenario such as this by seeking to imply a term. That is more of an exception rather than the rule. Because it is not the job of the courts to conclude a bargain between the parties. If the parties fail to conclude a bargain, the courts are not going to conclude that bargain for them, because that violates the principle of freedom of contract. Okay, so that's a basic idea, and it is difficult. Imagine also from a policy point of view that because I tell you something of a business opportunity, therefore I need to be part of any business that you develop as a result of what I tell you, and that therefore you are now bound. We have entered somehow into an implied bargain that if you profit from the idea I gave you, I must be part, you must share with me the profits. That seems to be something onerous. That's something that the parties have to discuss and agree upon. Wouldn't you agree? Because otherwise, by me telling you about every single business opportunity, that would actually mean that you would be precluded from pursuing or exploiting that business opportunity on your own without involving me. And the courts or the law cannot possibly, make that kind of presumption. Simply because it violates the freedom of contract between the parties. Okay, so that's difficult. So in this case, if the question is whether or not irrelevant implied term could be read into the contract, that Sanil cannot profit from the business opportunity without including Lachlan, the answer would be no. Okay, so the agreement between Sanil and Lachlan wouldn't have included an undertaking on the part of Sanil not to exploit the business opportunity for himself. That cannot be implied. Now, as to the final question, whether or not Lachlan should be paid $100 for writing part of the chapter despite his agreement not to ask for any money.
I'd say he is entitled to the $100, mainly because he has accepted the terms that Sunil put forward and has started to actually write the chapter.
Hold on, where was this point? Okay. So what has happened, based on the facts, it would seem, is that after Lachlan started writing the chapter, he then agreed for the contract to be terminated and said that he did not need the money. Okay. So in that case, because Lachlan has said, I don't want to be paid any money, is it possible for Lachlan later on to ask for the payment, notwithstanding the fact that he actually has agreed not to be paid the $100?
See, I'd say he would be entitled to that money still, because from what I'm reading, he's agreed to terminate the contract, but has obviously slipped his mind to ask about the money. He hasn't said that, oh, no, I won't. You don't need to pay me, that's all good, which is in turn changing the terms of the contract after having made it. But he's actually just saying, right, the contract's at an end, and then because of other circumstances, he's realised, oh, wait, he didn't actually pay me for that.
But what if Lachlan actually was quite clear in saying expressly he doesn't want to be paid?
Well, then I'd probably say that he's given up he's waiving his contractual rights. He's basically saying, okay, I know I'm entitled to this money, but I don't want it, so that's okay. So I'd say he's waived his right to take that money.
Okay. Now, would you say that in that situation where, so in the first instance, we agree there was a contract between them for Lachlan to write a chapter for Sunil. We agree on that, right? Now, this aspect, the scenario whereby Lachlan then agreed not to be paid $100, would you agree that that would constitute a separate contract? Potentially a separate contract. There was an existing contract that has been concluded, right? So
yes.
when Lachlan said that he did not have to be paid, and presumably that was accepted by Sunil, did that constitute a contract or not?
Yeah, you could probably construe it so that it is a second contract, because Lachlan is offering to terminate the contract with consideration that he won't take any money. Right. And Sunil is accepting those terms.
That's good. So that's correct. We should look at it as a second contract. We're saying that because if we do not look at it as from the viewpoint of a second contract, then what would have happened is that there was an offer on the part of Lachlan to waive the money. Now, if that offer hadn't been accepted, then you can say that there was no contract, and therefore the money would have been due still to Lachlan. So therefore we have to say that there was an offer on the part of Lachlan not to be paid, and that offer was accepted by Sunil, right? So there is a second contract. Now the question though, so the first contract has been concluded. There is a second contract whereby Lachlan offered not to be paid. And we assume that Sunil accepted that offer. So they have a contract. The question though is that contract valid? So in other words, Assuming that the offer of Lachlan to waive the $100 was accepted by Sanil, could Lachlan then say, so assuming that Lachlan was explicit in saying, I don't want to be paid, don't pay me, clearly, expressly, no doubt about it. Sanil accepted that contract, that offer. So you have a contract, right? An offer was accepted, you have a contract. Question is that a valid and binding contract? So when I say there's a contract, we're saying that there was a consensus ad idem. There was a meeting of the minds. The question though is, will that contract be valid and binding? Will that agreement be valid and binding? That is the next question.
I'd say that it is binding, mainly on the fact that consideration has been provided.
Did I hear you say yes or no that the contract is valid or the contract is not valid?
Sorry, I'd say the contract is valid, the second contract.
Okay. What exactly is the rule concerning contract formation? What are the key elements there?
The parties have to agree.
Huh? What was it?
The parties need to agree.
Yes. So assuming that the parties agree, there seems to be an agreement here. But what is one of the key elements of a contract that must be there in relation to contract formation? Consideration. What's the rule on consideration that is relevant to the third question here?
Value should be given.
Okay. So if we remember now that consideration is one of the key elements of a valid contract formation, what does it suggest to us in terms of answering the final question here? Did Sanil provide consideration for the offer of Lachlan?
No.
Okay. If Sanil did not provide a consideration, what is the implication then in law?
There is no contract.
There is no contract. There is no valid contract. Because for you to have a valid contract, you need a consideration.
And the consideration will be in the form of the $100, if it was.
It will be the form of, in terms of Lachlan, giving up his $100. What does Lachlan get out of it? What is the consideration for Lachlan's offer to Sanil to give up the $100?
So Sanil could have made consideration if he had said, well, you've done this amount of work, so how about I pay you $50?
Yes, possibly. But again, that scenario, Luke, we just have to be, we're kind of running out of time, but we just have to be careful about a situation where, that aspect where if you have a debt and you agree that the debt is lowered, you reduce the amount of debt to be paid. We just have to be asking the question really that in doing so, what is the consideration there? So the mere fact, for example, that Sanil says, oh, don't pay me, instead of paying you $100, I'll pay you $50. Is that sufficient consideration to have a contract that's valid?
Yes.
Probably not.
Right.
Probably not. Because what, again, the consideration of Luke, we go back to the question of what exactly is the consideration as far as Lachlan is concerned to him getting $50 only instead of $100. The mere fact that he gets paid $50 is not consideration. He was meant to get paid $100. What is the consideration for him agreeing to only get paid $50? There still isn't any consideration.
Okay, so for example, if Sanil had turned around and said, well, I've now bought this business opportunity, and since you've done this little bit of work for me, how about you join me as a partner in this opportunity?
Yes, that would be the consideration there. That would be the consideration. That would be valid. But if Lachlan in the process were to agree to just get paid $50, the question still is, what is the consideration there? There isn't any consideration. There wouldn't have been a valid contract. But in the scenario gave Luke, where Sanil agreed that Lachlan would be part of a new business opportunity, that would be sufficient consideration, obviously. Okay. Any questions before we end tonight's tutorial?
No, good on my front, Manjo.
Thank you very much. I'm glad that there were, at least you and Heidi were here, so we were able to do this tutorial, and we leave it to the rest of the classmates of yours to just go through the recording then. Okay, so have fun this Friday, and I hope to see you on Monday.
Thank you, Manjo.
Thank you, Heidi. Thank you, Luke. See you. Bye.